message from one Kathy Freese, a lawyer who worked for the Trump campaign. And what she says is, most immediately, we were just granted access by written invitation to the Coffee County systems. Spelling mistake there. Yay. Putting details together now with Phil, Preston, Jovan, etc. So this is where I'm getting this letter of invitation. So when the government said in response to my email, they didn't know what I was talking about, that was troubling. But then when I sent them this article, Mr. Wooten responded again and said, we've reviewed the article and do not have this letter. Didn't appear to know that it even existed. That's what they said, and that's as of September 18th, 2023, Your Honor. That date is important. So it's important, Your Honor, because discovery has now started to be produced. And I do get the GBI report. And the GBI report was produced just 2 days ago. But before that, when they said they didn't have this letter, I went out and I actually called witnesses. And I got the letter of invitation myself. It does exist. So I was able to get it and I attached it to my other motions in this case, right? Because I believe it shows that this was authorized. But then I get the GBI report yesterday or 2 days ago, and I start looking at it. I spent all night because it's 20,000 pages long. And I found a 390-page summary of everything they did and found. And what did I find? Number one, if we can bring up Exhibit 6, it shows that this investigation by the GBI has been going on for a year. August 15th of 2022, they have been digging into Coffee County. It goes on. It goes on. And what's troubling to me, Your Honor, is this. If you go through that report in some detail, and as I did, you see on page 277, the GBI, as of August 3rd of 2023, if we can go to the next exhibit. This is the report, Your Honor, that shows that, in fact, if we can scroll down, they had the letter of invitation and they also had the request that preceded it. And there's two critical things from all of these. It's a 5-page report or 4-page report, Your Honor, I can submit for Your Honor review. It was attached to my motion, my reply today. It shows two things. Number one, the request to get into those systems was not from Sidney Powell. That's the first thing. The second thing is they authorized it. And it goes on to analyze that authorization. And what's critical, if we go up again, they had that information as of August 3rd, 2023.
The GBI did.
The GBI did, which arguably, because now the government has it, they're part of the government team, Your Honor. And it demonstrates that as of August 3rd, they knew that, number one, Ms. Powell wasn't involved, and number two, that it was authorized. And that knowledge is imputed to this government team. So when they respond to me, and we'll go on, Exhibit 8 is, another pages from this report, page 345 from that same report, where they go through 10,000 emails that they happen to have of Misty Hampton, 10,000. Of the 10,000, they note 3,000 were between November 1st of 2020 and March 1st of 2021, and they say they found 7 emails of particular interest, Your Honor. What do they all have to deal with? Authorization provided by Misty Hampton and the fact that this individual, Preston Halliburton, submitted some requests to get there. So of 10,000 emails, they find 7, all of which are exculpatory to Ms. Powell, none of which were produced to me. Instead, when I ask for these letters and for this information, I get told by the government, we don't have it. Well, in fact, they did. They did have the letter. They had it the whole time. And what's troubling about it, Your Honor, is not just that when I asked for it, they didn't produce it. What's troubling is they had it before this case was ever presented for indictment in August of 2023. And it shows that this was authorized. And that information couldn't possibly have been presented to the grand jury because the government didn't even know it existed. Now, they don't have an obligation to produce exculpatory material. I understand that before a grand jury, but they certainly have an obligation to produce the truth. And it raises questions. What law were they instructed on about authorization if Misty Hampton's letter authorized this? And it was at the request of somebody other than Ms. Powell. It's Brady, Your Honor, but it goes more. We can go to Exhibit 10. Exhibit 10, Your Honor, is a copy of the contract, which is referenced in this indictment multiple times in every 32, 33, 34, 35, 36, 37, all those counts, they talk about this contract, okay? It's a contract that, number one, has nothing to do with Georgia, but which they're saying all of this stuff in Coffee counties were acted upon. That's the first thing it shows. But the second thing that it shows, which is equally
Judge, I'm going to object to publishing things that are not relevant to the motions before the court. I don't think this is the time for Mr. Rafferty to put up a factual defense of the case. It's not appropriate and it's not relevant. We haven't, first of all, we kind of gave him some leeway. We haven't seen any of these exhibits, but I think it's gone a little bit too far.
Your Honor, the original motion that I filed that they have already responded to had in it what I'm about to talk to. So they have seen this exhibit. It was buried within it. It was the metadata from the contract, which they have been talking about as evidence of her participation in this. And what the metadata that they sent to me, buried in all this discovery, shows is that, in fact, Ms. Powell did not sign the contract. Their own metadata shows that it was signed by Jim Penrose. It was not signed by her.
All right. So in response to the objection, Mr. Rafferty, before you introduce any exhibits, I would ask that you show them to opposing counsel. You can make them part of the record. I didn't see this hearing as being a full-throated defense, and so I'll give you some leeway, but we're not going to go through the entirety of why you think your client shouldn't have ever been indicted.
I understand that, Your Honor, but I do think it's important because the government has alleged throughout this indictment, as it relates to this particular exhibit, which is in front of the court, that Ms. Powell signed this contract, that it was done by Ms. Powell repeatedly throughout, when their own discovery shows that she did not. It shows right here in the middle of this document that Jim Penrose signed this. And if you look at the contract, it's not even a signature. It's somebody typed her name. So when it says Sidney Powell, somebody typed it. And the person who typed it is James Penrose. So when they allege throughout this indictment that she signed it, that is simply not true. And they had the evidence of that. I didn't. I just found it in the discovery.
Again, when we say they, we mean the GBI, right?
No, I mean the government. This is not within the GBI report. This is other stuff. But again, going back to it, they is anybody on the prosecution team. It doesn't really matter if they can control the GBI or not. You know, we've been asking about special purpose grand jury transcripts. They've turned over Misty Hampton's grand jury transcripts. I've had a chance to look at that. It is in the motion, Your Honor. It does demonstrate Ms. Powell had nothing to do with this and that she authorized this. I have that now. We have the Coffee County group texts, which are also now in discovery. They demonstrate other lawyers, Charles Bundren, Preston Halliburton, all of these people. Ms. Powell had nothing to do with this and that she authorized this. I have that now. We have the Coffee County group texts, which are also now in discovery. They demonstrate other lawyers, Charles Bundren, Preston Halliburton, all of these people, not Sidney Powell, had nothing to do with this.
Well, let's go that route. I want you to list exactly what is it that you think is outstanding that you should have.
Well, if the government says at the beginning, Your Honor, number one, that they have 8 terabytes of discovery, and I have maybe 2, that means there's 6 terabytes of stuff I haven't received. So that's one thing that I'm entitled to. Number 2, Your Honor, since we now know that they have access to the GBI file, what I'm also entitled to is written responses to my requests that, do you have these materials? And it's not good enough, Your Honor, because we've seen in this case already, it's not good enough. And we've seen it in cases all over this country, frankly, where prosecutors say, I'm aware of my Brady obligations and I will comply. We've all seen that. That's why Rule 5 was amended under the Federal Rules of Criminal Procedure, because that was proven to not be good enough. And throughout the country, there's 3.8 professional rules of conduct about Brady, because Brady is an epidemic. Brady violations are an epidemic because the government doesn't always comply. And so what I'm saying, Your Honor, is when I submit a Brady request, I'm entitled to a response, and a response that's not just, we know what our obligations are, here's your discovery. That's not sufficient. That doesn't satisfy Brady. But, Your Honor, I could go on. I've seen Scott Hall's interview. We've listened to it. And what's troubling about that is the same thing. He was told he was authorized. This was just last week he was interviewed. 3 hours. We have 3 hours of recordings where he says, we were authorized. Somebody told me we were authorized. That's what he says. He's asked about Sidney Powell. He never talked to her. Equally important, Your Honor, you hear on the same recording, the government says, we're still trying to figure this out. Well, for Ms. Powell, she's sitting here
I'm going to object again to talking about evidence that he has. I don't see how evidence that the defense has is subject to any kind of a Brady issue. This is going way outside the bound.
It bleeds into the due process and the motion to dismiss, Your Honor.
Well, let's turn to that then.
So, Your Honor, what I think I've shown is, number one, these bald statements by the government that they've complied are not sufficient, that they need to respond, and they need to respond in writing to the requests I've made. And they need to inquire of the various agencies that have helped with this investigation to find out about the very specific things that I've asked for. And that extends to grand jury and special grand jury transcripts of individuals who testified and who were asked and said in whole or in substance that they've never spoken with Ms. Powell, that she had nothing to do with this. They never emailed her, that she wasn't in a meeting, anything like that. It's not good enough for them to say, we're going to turn over the special purpose grand jury transcripts for the witnesses we're going to call, because that does not satisfy Brady. So they have to answer for those sorts of requests, Your Honor. But more importantly and fundamentally, the motion that I filed lays out all of the different things that shows that the government had, that Ms. Powell was not involved. And it begs the question, how could they possibly have gotten an indictment that is based on evidence and facts if they actually presented the evidence, especially when their own emails and acknowledgments say they didn't even know some of these letters of indentations existed. Ms. Powell's role in this case depends on Coffee County and the idea that this visit was unauthorized when the record now shows it was. But it also shows she was not involved. And if the evidence was presented to this grand jury that she was involved or that it was not authorized, that testimony is necessarily false. And the indictment should be dismissed, Your Honor. And that is what I'm asking for.
And what is the legal authority that this court has to dismiss an indictment based on false testimony before a grand jury?
The legal authority, Your Honor, begins on page 18 of my brief. Okay. The due process clause forbids the government from introducing or failing to correct testimony that it knows or reasonably should know to be false. That's the Napier versus Illinois case, 360 U.S. 264. It goes on, Your Honor, if you go on to page 19. The same principle applies to the state's presentation of evidence to the grand jury. Napier has been extended to grand jury proceedings. In other words, a due process violation ensues when a prosecutor knowingly presents perjured testimony material in nature to the grand jury. The state must not force a defendant to stand trial on an indictment which it knows to be based in part upon perjured testimony. And if all of the evidence that I presented, which the government—
Let me stop you there. So you just read from a Ninth Circuit case. That's not a Georgia case, right?
It's a federal case, Your Honor. I understand that.
So has the Georgia courts ever adopted this holding of the Ninth Circuit?
Your Honor, not that I'm aware of.
Is the 11th Circuit?
Not that I'm aware of.
And I think the 11th Circuit actually explicitly disavowed it. So you're asking me for something that the trial court does not have the authority to do.
Well, I think the court has ultimate authority to oversee this prosecution and make certain rulings based on the evidence that's presented to it. And the evidence that I presented, which is not really responded to at all, is that the grand jury testimony that was presented must have been false, because ultimately the evidence that they had shows she wasn't involved in Coffee County. And to the extent that anybody did something in Coffee County, it was authorized. And they had the evidence of that. And they couldn't possibly have presented it to the grand jury because they claimed to me they didn't even know it existed. So I'm asking the court to use its authority to hold the government to its burden as it relates to Brady, but more importantly, to dismiss this case as to Ms. Powell. I've been saying it from the beginning. I've asked the government to do that. They won't do it. So I'm asking the court. We don't need to sit through a 4-month trial, which they have said, where they know that the evidence is Ms. Powell was not involved in this, and this visit to Coffee County was authorized. I'm going to be sitting at a table for 4 months where everyone in the courtroom, Your Honor does, everyone on the defense team does, the court reporter knows that that's not right, except for this jury. They're going to be sitting here waiting for 4 months. Does that seem like consistent with due process? I submit it's not.
Thank you, Mr. Rafferty. Mr. Wooten.
Judge, I do have a PowerPoint with a couple of exhibits that I'd like to give.
What would happen if the subscription ever expired?
I don't know. I think there's some up there. So, Judge, I want to start with a few things. I think we've addressed most of this in our written response. So I'm going to move quickly through the PowerPoint. But before I get there, I want to hit a few points in response to Mr. Rafferty's argument. First of all, we heard a lot about his version of the facts. As we've pointed out in our response to this motion and other motions, this is not the time or the place to argue the facts. That's for 12 people that are going to sit in that box right there. And I guess the court said about 6 alternates. That's who that type of argument needs to be made to. Not the state, not your honor, but to the jury. He said over and over that his client was not involved. He said over and over that there's some letter of authorization that let her do what she wanted to do if she was involved. Once again, completely outside the boundaries for this type of hearing. Those are all things that the state believes it can prove beyond a reasonable doubt that are incorrect. We believe she was involved. We don't believe that there was a letter that granted any kind of lawful authorization, but we'll save that for the jury. Again, Brady doesn't apply to materials that the defense has. And I'll dig a little bit more into that, but we've heard over and over about Brady this, Brady that, and then I learned this from the state. The state gave me this in discovery. I don't see how things that are in the defendant's possession are subject to any kind of a claim whatsoever under Brady. Also, we heard a needle in the haystack argument. The fact is there is a lot of evidence in this case. We did request an 8 terabyte hard drive. That doesn't mean we have 8 terabytes of discovery. We've turned over everything that we do have. And the fact that there's a lot of evidence doesn't mean that we're hiding exculpatory materials in there. That's absolutely not the case. Also, Judge, you asked Mr. Rafferty for the legal authority to dismiss this indictment. And he gave some explanation, which, as the court correctly pointed out, is not controlling law in Georgia. In fact, is kind of the opposite. What he also didn't do was give any evidence to support his claims of misconduct. And so I'm going to jump into the PowerPoint now. And the fact is the defendant's pleadings and his arguments are based on falsehoods. And the state takes these allegations against us very, very seriously. The allegation that we're withholding evidence, suppressing evidence, and that we're committing prosecutorial misconduct are outrageous. They're not true. Number one, the defendant says in her motion, quote, to indict Ms. Powell, the district attorney and special prosecutor necessarily committed prosecutorial misconduct. That is absurd. It's unsupported. The court has heard no evidence other than we don't like the fact that we got indicted. We disagree with the state's theory of the case, and therefore there must have been prosecutorial misconduct. That is not how this works. Number two, quote, Sidney Powell is innocent of all charges alleged in the indictment. Because of this, the state necessarily has possession of significant evidence that exonerates her of all charges. Again, that is absurd and it's unsupported. Same argument. We don't like that she got indicted. We don't agree with the state's case. So there must be something out there that exonerates her. Number three, they say to this day, Ms. Powell has not received any of the documents requested. That is absurd. It's not supported. And frankly, it's a lie. It is absolutely a lie. I'm going to start with that the pleading is avoid speaking demur, and we've responded to some of this in our other responses. A demur that attempts to add facts not otherwise apparent on the face of the indictment presents no question for decision and should never be sustained. Speaking demurs present no legal authority for quashing an indictment. Speaking demurs are void. And this is from State versus Givens, 211 Georgia App 71, 1993 case. Move a little bit into the substance. Again, the pleading raises no cognizable prosecutorial misconduct, and you've heard no evidence of that here today because there was none. A charge of prosecutorial misconduct is a serious charge. It's not to be made lightly, and a defendant who raises that claim has a duty to prove it. And you've seen no evidence, nothing, not one witness. You've seen reference to some emails, again, an argument, speculative argument that there must have been prosecutorial misconduct because defendant doesn't like the outcome, doesn't like that she was indicted. But I guarantee every single defendant that's indicted in this county doesn't like the fact that they were indicted.
Any thoughts on this GBI report that apparently has just come up recently?
Yes, Judge. And I'll touch on that a little bit later in the PowerPoint, but just so the court's aware of the facts there, we became aware of that report last Thursday. The Attorney General's office, that's who was working with the GBI on that investigation. When that investigation began, our special purpose grand jury investigation had been going on for months. And so our investigation was independent of the GBI's investigation. We had witnesses that were subpoenaed to come in and talk about Coffee County. We did not know that they were conducting an investigation. There was some media, reports that there was some sort of an investigation, but the fact is it was the Attorney General's office that was working with GBI on that. The Attorney General's office let us know on Thursday that they had this case file. I believe the case file was completed and turned over to them on Friday of last week. We picked it up on Monday of this week, and we made it available to the defendants on Tuesday of this week. So I'm not sure how we could move any more quickly than that.
Were there any GBI agents participating in the special purpose grand jury's investigation or at any point in the pretrial proceedings in this case?
Only to the extent that there was one or two that were witnesses to a signature match audit that was going on in Cobb County in late 2020. But that's it. They were not assisting with our investigation. Some of them did come in as fact witnesses, but had nothing to do with Coffee County. Again, I just want to hit very briefly on the fact that the defendant seeks to improperly inquire into grand jury evidence. He says that something about he wants transcripts or wants to look into the evidence that was presented to the indicting grand jury, that he doesn't like the outcome, and therefore there must have been lies told to the grand jury. That's absurd. That's absolutely absurd and not based on any evidence. And as our Supreme Court has held, that when a competent witness is sworn properly and testifies before the grand jury, and where the defendant's therefore thereafter found guilty beyond a reasonable doubt, which that has not happened yet here, the sufficiency of the evidence to support the indictment is not open to question. Again, he's shown no evidence of prosecutorial misconduct because there was none. Defendant's false claim that because she was indicted and because she maintains her innocence, that the state must have misrepresented evidence and suborned perjury is, one, unsupported by evidence. Two, it's offensive and it's inappropriate given the serious nature of this type of allegation. And three, it's a frivolous use of the court's time. I'm going to move into the Brady motion. Essentially, Judge, the defendant seeks things that are not Brady material. And to quote our case law, to prevail on a Brady claim, one must show that the state possessed favorable evidence, that the defendant did not possess that evidence or could not obtain it with any reasonable degree of diligence, that the prosecution suppressed it, and that there's a reasonable probability that the outcome of a proceeding would have been different. That's coming from Waldrop v. Head, 279 Georgia 826, a 2005 case. And so I want to stop here for a second and address some of the arguments that were made. We received this list of, I think it was 30 in the letter and 37 in the motion, categories of evidence that Mr. Rafferty believes exists. We have told him that those things don't exist. We can't make evidence appear out of thin air. We're not responsible for turning over things that we do not have. The court knows that. And again, I'm just making a record here, but we can't be made to turn over things that either don't exist or that we don't have. We've turned over.
Define we for this case.
Judge, as the court kind of alluded to, we don't believe that GBI is under our authority here. This was an independent investigation of the Fulton County District Attorney's Office. There's no law enforcement agency that was a partner agency with us here. And so we believe that it's kind of limited to the Fulton County District Attorney's Office. There's a few areas where that might expand a little bit. There was some evidence that was obtained with regard to the Ruby Freeman incident out of Cobb County. Certainly anything that Cobb County has, I think we have a responsibility to get and turn over, and we've done that. Certainly anything the GBI has as it relates to what they gave to us, we have a responsibility to get it and turn it over, and we've done that.
Are there any other law enforcement entities, either in Georgia or nationwide, that you've identified or made requests to, or that you're trying to get their materials?
No. No.
And what's the one in Cobb County? Was that the sheriff's office?
Cobb County Police Department.
Police Department. All right.
Yes, sir. And again, we've received that complete case file and we've turned it over. I also want to talk about, Judge, like I said, what we have turned over, and these have been provided to the defense. They were also attachments to our response. We turned over our first batch of discovery, as the court I'm sure remembers, in open court. I believe that was September the 14th of 2023. We turned over a second batch on September the 20th of 2023, third batch on September the 26th of 2023. So we have turned it over on an ongoing basis. We're not holding anything back. We're not hiding anything. Again, I realize this is very small, but this is one of the emails that I believe Mr. Rafferty put up related to this purported letter of authorization or letter of invitation. Again, as we pointed out in our response, we don't believe that this purported letter proves what Mr. Rafferty believes it proves. But when it was requested from us, we looked at our materials to see if we had it. We did not have it. We said, please give us the media story that you're saying references it so we can make sure. We took a look at the media story. Again, we said, we do not have it. We don't have what you're talking about. So we could not turn it over. It's not Brady material. Additionally, like I said, and this is what I referenced, this is an email showing that when we received the GBI materials on Monday, we immediately made them available to Mr. Rafferty. We're not hiding them. We're not holding anything back. We got it from the AG's office, immediately started copying it, and turned it over. Again, like we talked about, we don't believe that our Brady requirements are imputed to agencies that we have no authority over. I know that the court's familiar with that case law. Additionally, one more exhibit showing that we, as recently as 12/20 today, turned over some special purpose grand jury transcripts that we received yesterday and today. So as soon as this is coming into us, we are turning it over. Additionally, the defendant's Brady motion seeks non-discoverable attorney work product. He asked for things like our notes, like logistical scheduling communications, and we've listed kind of some of those things in our written response. But as our courts have held, attorney's work product is generally non-discoverable, non-exculpatory information, and an attorney's work product does not become discoverable simply because the opposing attorneys might find it strategically useful. Foster versus the state, 258, Georgia 736. Since much of a prosecutor's work product will not fit the definition of exculpatory evidence subject to discovery, only that's actually exculpatory must be turned over, and we have done that. That's Waldrop versus Head, 279, Georgia 826, a 2005 case. And Judge, I can't let this go. The defendant in his motion made false representations to this court. He requested, and again, this is going back to this letter of invitation, any and all evidence regarding a written letter of invitation from Coffee County officials, leadership, or representatives, Catherine Price, Rudolph Giuliani, or others granting authorization to examine voting machines. Where I kind of let off was the requirements for a Brady claim. First is that the state has it. Second is that the defendant doesn't have it. So in categorizing something as Brady material, the defense is essentially saying, we don't have it. We're entitled to it and we don't have it. And the day that this motion was filed, another motion was filed by the defendant, same day, that attached the purported letter as an exhibit. So if the defendant had it in his possession and is saying that he doesn't have it, that it's Brady material that the state needs to turn over, that's a serious problem. The defendant has shown no evidence of a Brady violation. His false claim that Ms. Powell's false claim that because she maintains her innocence, the state must possess exculpatory evidence. It's unsupported by any evidence. It's a willful misrepresentation of the fact that the state has turned over all of the exculpatory evidence in its possession. That's all I have, Judge, unless you have any questions.
Yeah, I want to explore the needle in a haystack authority, if you've had the ability to look into that. Essentially, if you have any thoughts about document dumps in criminal cases. We don't deal with that in all of our cases. Usually it's a little bit more manageable, but, and I don't know if, I think Mr. Rafferty actually has shown that he's not afraid of the haystack. I don't know if, I think he's found all the needles as they exist, but regardless, what's the
I don't know that I found all the
We'll get there.
There's probably more. I'll just keep looking.
All right. So what to that end? Because essentially what I'm trying to figure out here is what is it exactly that I'm expected to do with this, in terms of the Brady obligations or the purported ones. Essentially, it seems like Mr. Rafferty is asking for, in effect, kind of civil interrogatories and wanting you to be able to respond to each one of them. So that's what I kind of want to put to you is what's your position on that, and to what extent does the state have an obligation to point to things within the 2 terabytes of data?
Sure, Judge. I mean, I don't.
What legal authority suggests it one way or another?
I don't have those cases in front of me, so I could provide a written response if the court wants to, but that would actually cite to authority. But I can say the state's position is that we don't have to say, hey, here's the folder of all of our worst evidence or all of your best evidence. That doesn't make any sense. We've turned over all this evidence in an organized fashion. It's not like it's one folder that has, 50,000 documents that have no titles or description or anything like that. It's organized in such a way that Mr. Rafferty can go in and find the Coffee County stuff. And so I don't think we have an obligation to narrow it down any more than what's a reasonable organization. I don't think we need to say like, hey, these are, our 5 worst facts. Here you go. Good luck with your case. I just don't think that that's the case, Judge. That's our position. And again, if Mr. Rafferty wants to give the court some specifics as to how it's too difficult for him to filter through the way that we've turned it over, I think it's his burden to show that. I mean, I don't know what's difficult about finding the discovery because he hasn't said specifically what the challenge is.
I'll say it now, Your Honor. There are folders that say Coffee County, and there's a handful of documents in there. There are other folders that say miscellaneous documents or miscellaneous digital. And buried within there, I find something that is from Coffee County. Extensive documents, attachments that have no descriptor. They're just a number. If I click on it, wow, there it is. The metadata that I described in my argument. I just happen to have somebody else helping me look through all this stuff to find it. And I've asked for very specific things, Your Honor. I don't think it's that difficult. If I'm asking for stuff that shows Ms. Powell was not involved and this was authorized correctly, apparently, or not, those are 2 very simple categories of information which exculpate Ms. Powell. They don't even respond. And the reason why this motion had to be filed, Your Honor, is because and over again for these documents in emails, and I don't even get a response. You talked about courtesy at the last hearing. Answer me. If you have it, great. If you don't, answer me and say you don't. We wouldn't be here. He talks about wasting the court's time. I shouldn't have to file this motion if he just answered me and looked. And when we talk about me misleading the court, I went out and found that myself. He said they didn't have it when in fact the GBI did. And there's evidence, Your Honor, that the GBI got data from the Fulton County DA's office over a month ago. He's testified or just argued before that multiple witnesses testified from the GBI. So they are part of the same team.
I'm going to get you, Mr. Rafferty, I'm going to get you a full chance to respond. Now I think we're getting beyond how the folders are organized. So let Mr. Wooten finish up and then they'll be back to you.
And
okay.
Judge, again, I just rely on the former prior response. I need to hear specifics about what's difficult to navigate. And again, we don't believe that we have to pinpoint, these are the 5 best files. These are the 5 worst files. And here's your defense. We don't believe that that's our job. We haven't hidden anything anywhere. It's been turned over. It's a lot of discovery. But that doesn't make it a needle in the haystack situation.
Okay. Anything else, Mr. Wooten?
No, Your Honor.
All right, Mr. Rafferty.
Thank you, Your Honor. What I was going to say with respect to the argument about who's a member of the prosecution team, my co-counsels have cited for me a case. It is irrelevant that a police agency may have possessed the favorable evidence without knowledge of the prosecutor. The law places the responsibility and ultimate burden on the prosecutor for the failure to provide the favorable evidence to the defendant if any part of the prosecution team possessed and suppressed the favorable evidence. That's Kyles v. Whitley, which we've all seen, which is also cited to Head v. Strickling, 277 Georgia 403, 2003.
What is that, 95?
2003.
2003, okay.
2003, Your Honor. And the point of this is he's now said that there were witnesses from the GBI that participated in this that may have actually testified in some capacity. They were clearly part of the team. My co-counsels have indicated new media reports are showing that the GBI got data from the Fulton County DA's office. So they're sharing data. They're clearly part of the prosecution team. So it's irrelevant, as I said before, whether the DA's office has ultimate authority. A U.S. Attorney's Office does not have authority over the FBI. The FBI and the U.S. Attorney's Office work together on a case. The U.S. Attorney's Office is held to the responsibility of what the FBI possesses. Similarly here, the DA's office clearly, by his own admission, worked with the DA's office on some level. They're part of that team. They possess this information. He's obligated to turn it over. And what I pointed to, Your Honor, is just one example. There are other documents that I can cite to. I can show you where it's just a number. It's a PDF that just happens to appear. If I click on it and look through it, I see that's what it is. I see it's a document that's relevant to Coffee County. It doesn't even appear in the folder that says Coffee County. So it is a needle in the haystack that I found. The metadata is a needle in the haystack. And I've made clear repeatedly the defense in this case, what it is. And again, we would not be here if they would just simply answer, we don't have that, and answer after you do a meaningful look. Mr. Wooten responded to my email within a few hours saying, I can't find it in my folder, so we don't have it. But that doesn't satisfy your obligation. What you have to do is actually go see if it exists. Because if they had, they would have known before they got the indictment that a letter of invitation existed. Because it existed in the GBI's file as of August 3rd of 2023, before the indictment was ever returned in this case. And it is not just a letter. There's multiple communications that are referenced in there. There's the individual that was responsible for asking for it. There's emails back and forth. In fact, there's an individual who's the head of the Board of Elections from Coffee County who was copied on some of this. So this is favorable stuff, very favorable and exculpatory to Ms. Powell that I asked for. And they said it doesn't exist when in fact it did. And so, I mean, I'm at a loss here, Your Honor. As I said, we're going to be sitting here for 4 months trying a case where there's all this evidence that they have that they know Ms. Powell wasn't involved. There's text messaging, communications, documents, all of which show the same thing. And their response is simply, well, it's a speaking demurrer, so we'll see what happens at trial. Is that really the way justice is supposed to work? I mean, we are parties to this litigation. You are the judge and you call balls and strikes. And ultimately, you have authority as a judge to decide things here about whether this case should go forward and what testimony was offered. And to look at what I presented and think about what evidence must have been before the grand jury that can't possibly be true. And so I just reiterate my arguments, Your Honor, and I'd ask the court, number one, order the government to respond to Brady in writing, specifically to make a meaningful look, but also to dismiss this case, Your Honor. I submit that due process demands it.
All right. Well, thank you to both sides for being flexible today as we make our way through these motions. So I think it's safe to say that both sides vigorously believe in the strength of their case. And I don't think there's any denying that. And assuming without deciding that the state's case survives the other pretrial motions, when two sides believe that, that's why we have our jury trial system. I think we'll get to the Brady issues, because obviously I think in a perfect world, everything gets turned over in one batch all at once, and then we can just focus on interviewing witnesses and stickering our exhibits. But I think the reality is we've known, anyone who's tried a case is that things ebb and flow. And certainly in a case as complicated as this one, discovery can be a evolving thing. So I think at a minimum at this point, the defense motion to dismiss an indictment. Obviously, Mr. Rafferty is put forth what I would think be a thorough and presentation of what he intends to argue. It's got his exhibits, but in terms of where we are procedurally, that continues to be my focus here. And there's a Ninth Circuit case that applies this to grand jury proceedings. There's nothing in Georgia, and there's nothing even in the 11th Circuit as persuasive authority. And the idea, what we saw in the Olson case, which we've already talked about from our previous hearings, is that Dismissing an indictment is also something where you have to show prejudice. It's something that's not done lightly, and it has to be something that's done with a concrete reason. And just purely on procedural grounds, I don't believe that this motion to dismiss for misconduct and is it pronounced Napu or Napu? I don't know, but I don't see that as clearing just the procedural bar of being something that's under the court's authority, because this isn't something where, as the Constitution says, it's the jury's role to decide contested issues. And I believe if the state wanted to, they could have sat here and we could have a preliminary trial that would last weeks as well. But that's not what we want to do. And certainly I can sympathize with the idea that someone who vigorously contests and believes in their innocence doesn't want to have to sit through a long trial. But that is the state's right to do. I can limit it in certain ways if there's a 403 cumulative issue, but that's simply the process as it stands. So when it comes to the Brady issue, though, it also still feels like we're kind of shadow boxing a ghost here, where I'm trying to hear exactly what is it that may still be outstanding that needs to get turned over. I want this to be as smooth a process as we can make it. I'd looked at authority before coming here that says it in terms of what's part of the prosecutorial team is not simply a blanket, the police. It has to be someone who the state has authority over. So I'm not convinced at this point that the GBI qualifies. They're telling me that they received this evidence 2 days ago. They turned it over. Excuse me, it was Monday. So thankfully that's been flagged and was received now. So this didn't become a mess during trial. Hopefully these issues are limited. But I need to hear more exactly about what it is concretely that the state needs to be doing or what is expected to be ordered. I guess what's been asked is that the state be ordered to reply to each of these 37 questions or some iteration of how they remain. I'll take a look at the case law presented in there. And so certainly the intent at the last hearing was that, yes, it would be nice if the state could point to some of these issues and answer some of these questions, but ultimately what's nice is not necessarily what's required. So yes, sir.
Again, the state has taken the position that they're only turning over special purpose grand jury transcripts for individuals that they plan on calling as a witness. The court can order the government to look at all of the grand jury transcripts and respond if there are any other transcripts where somebody has been asked questions about Ms. Powell that shows that she was not involved, she didn't get the email, she wasn't in the meetings or something else. They can do that. And if they exist, they can actually produce those. If they don't exist, they can respond in writing. Because if subsequently in a later trial, Your Honor, because I've been through this in another case that Ms. Powell did the appeal on, is US v. Bailey. It was out of the Fifth Circuit where the government refused to turn over Brady material. It was related to the Skilling and Brown Enron case, right? A subsequent trial of other defendants who are more prominent than my client revealed in other transcripts that they didn't turn over to me that in fact there was Brady. The case got dismissed and Ms. Powell wrote a book called License to Lie about the whole thing. Okay, right. So there's a trial after my trial involving the president of the United States and 16, 17 other people.
Things will come up, I'm sure.
Those transcripts. And if that stuff gets turned over, we've
got an issue. So what you've given me the first kind of concrete example of something that maybe we can explore and that the trial court can do. What do you think, Mr. Wooten?
Judge, if I can have just 1 second.
And Your Honor, of course, if you do order that, we would like the same for Mr. Chesler.
Judge, we don't have any issue with reviewing for exculpatory evidence in those other transcripts. I believe we have done that to some extent, but we could take another look to make sure and turn over that anything that tends to be exculpatory. I think that's part of our understanding of our duty. We understand that.
And to be clear as well, I think it had been mentioned in the filings, there is no transcript for the grand jury that heard the case, right?
That's correct, Judge.
Okay, and I think that also goes to the motion to dismiss the indictment. Again, these may have something that is viable federally, but there's not even a transcript for the court to review, which is what the defense requested in its original motion. So I think that's another reason. Again, written order to follow, but again, why I think that motion to dismiss just isn't going to have much legs. So yes, sir.
There are probably investigative reports which haven't been turned over yet. I'm sure that there's interviews of witnesses that haven't been turned over yet. I do not know, but I assume that those are forthcoming at some point. Interviews of the people that are going to get called as witnesses. If those witnesses have said similar things that I described in the, like I described as it relates to the special purpose grand jury, that's Brady material. I'm entitled to it. Other documents similar to that. To do a meaningful inquiry of the documents themselves and their notes. I'm not asking for their work product. I'm not asking for every single slice of their case. I've told you what I contend is Brady. They have an obligation to look in their notes. If they met with somebody else that they didn't memorialize the report for some reason, look in your notes. Did somebody write down, oh, they said Ms. Powell had nothing to do with it. Ms. Powell wasn't there. Ms. Powell wasn't a part of this. If they wrote that on a piece of paper, a scribble scrabble, I'm entitled to it. They can look at those things. So that's what I'm getting at, Your Honor. The court at least has the authority to tell the government to go back and look at all of this stuff and ask the agencies.
Mr. Wooten?
Judge, we've turned over all the reports, all the witness interviews. It's all been turned over. Everything that was just listed. I take a little exception to the statement that I'm not asking for their notes because the motion asked for all notes that have to do with anything with Sidney Powell. I think we've addressed that in our response, but all of those things that he's requested.
I think we're narrowing in more on what we can actually do in this pretrial phase and what actually could be considered Brady. So to that end, if there is something in a note that's exculpatory, that's an interview of a witness that wasn't memorialized elsewhere, I think that would be an exception generally to attorney work product as it applies under the case law. So we can file an order directing many of these things, and the states would have the obligation to double check and triple check. And if during the second or however many trials we have, something else comes up, then the state's really setting itself up. We don't have to go down there, but I think we're clear there. Mr. Rafferty, any final thoughts or anything else that you would want to see in that order?
Your Honor, can I have 24 hours to make any additional suggestions that I can submit to the court?
That's fine. We'll just do this. I'll get a proposed order, and I'll be willing to consider that. Okay, so we'll consider those motions handled. Mr. Aurora has raised his hand. Yes, sir.
Judge, the government filed the notice and reservation of rights to discovery on September 27th. You said that opened up the door. So we've talked about this, turned over everything. I think you said witnesses now need to be turned over based on what we filed. So I just need to know on the record, have they given us all the special grand jury as sort of hinted that they may have to based on the reservation of rights?
Well, I may not have been too clear on that. That was at the case management hearing you're referencing?
Yes, Your Honor.
Right. I don't think I really jumped in and issued any kind of order or ruling based on some of those motions that have been filed in response. All right. What I was inclined to do there was, if the issue was going to be pressed, is to say that the state is expected to abide by its obligations to produce a witness list and be done with it. I don't really know what else to do with this notice. Mr. Wooten, do you want to add more to that than what we went into at the case management hearing?
No, Judge, rely on what we stated the last hearing. Again, it's just part of, we filed that as we do in many cases, just to make it part of the record in case there were something to come up on appeal.
Yeah, I don't think it's a creature of our discovery statute, Mr. Aurora. So I don't know how to dismiss a notice, but I don't think it's something that really has any legal viability. We'll address it as it comes up.
And I get that, but they're saying that anything that's in the discovery, as we talked about, that's not part of this. And so from the 20th, we've been sort of hinted that it could be the 10-day rule, what have you. I've listed 38 witnesses out of the 174 where I just have a name and nothing else. We haven't been given any additional information. I'm trying to track everybody down through their lawyers to figure something out. So
sorry, 38 names of what?
Witnesses on the list.
Oh, okay.
We haven't had it. And I understand it's a 10-day rule most of the time.
They've already provided you a witness list?
Of 174 names, 38 of which don't have really any information.
Okay.
Name. So I don't know how to reach out to those folks. And then when you get this notice on the 27th where it says anybody and everybody's fair game, as long as Your Honor is saying only the witnesses that comply with the rules, then that's fine. I won't press the issue about all the special grand jury notes that I asked for in a separate motion. But if it's, their position is whatever is in there.
Sure. Have you asked the state to maybe get a head start for the contact info of those other 38 names?
Your standing order, yes, I did. And your standing order says you got to give me real witnesses, not a phone book. So at some point, if we can speed that along, it would make this trial go a lot more smoothly, because I don't know how to do motions in limine based on, I don't know who specifically is coming in. So I could file you full of about 20 other motions for motion in limine to get January 6th or anything else. But if that's not going to be an issue, then I can save everybody some time.
Mr. Wooten, what do you think about being able to give him the contact info for these 38 other witnesses he's identified? It's going to be coming anyway in a couple of days, right?
Right. We're working on compiling that, and we intend to have it over to the defense.
I think isn't the 10-day mark would be in 5 days, wouldn't it? Yeah.
Yes.
All right.
And I apologize. The only reason I mentioned it, I mean, a month ago, they said, we got 150, we're definitely calling them. So that would imply that at least I have the information for 150 out of 174. That's just not the case. So you understand our frustration. It's like they make these bold representations. I assume they call all these people to the special grand jury, they would know how to reach them. In fact, in the motion for the special grand jury questioning that we're going to do, they said, if you don't have the information, the state still has it, and you can use their information to reach the special. You understand, you can't say I got 150, I'm calling for sure, and then say, I don't know all their information.
How to get in touch with them. Right. That would be an interesting approach, to think you could call someone and maybe they're out of the country for a couple of months. Who knows? So I would think that by the time we've got a hard list, we know that we're actually going to call them. Okay. And in terms of following up on that, the grand jury interviews, I think as indicated, we'll be making contact. Obviously, we've been tied up in another jury trial, but planning to do that, if not tomorrow, very shortly. I think, Mr. Hoare, you just wanted to have another mini case management hearing here, which is useful because I know I know we'd indicated perhaps Monday would work for hearing demurs and other things. I forgot to realize Monday's a holiday, so maybe there might be scheduling issues. I don't think it is for the county, but I think it's a Columbus Day, right? I don't. So regardless, actually, I think Monday might not be ideal because I'd actually want a chance to read and digest what you're filing in response.
I found 2 replies already. And
Sure.
2 more coming. Or it just takes a while to go through them.
So Monday was the 9th we had talked about. I think we'd also perhaps flag the Tuesday and Wednesday as times as well. Is this what you were wanting to talk about, was following up on scheduling?
Because you mentioned Monday the 9th and you
Okay.
said 16, 17, 18. That's awfully close.
Well, if we're done with substantive, do we want to go off the record? Okay. All right. So we'll be off the record. And so just talking scheduling. Yeah, the 9th is close. So can we look at the 10th and 11th alternatively? Okay.
State will be ready whenever Your Honor.
All right. And then we'll figure out, I think we already had some of the other defendants coming in the morning on Tuesday. So perhaps Tuesday afternoon would work. What else?
Jury questionnaire due what, Monday?
It's a great question. I didn't have to write it, so I was leaving that on you.
Jury questionnaire,
Monday? Okay. So then potentially we can use some time next week to start going through that as well. So how about this? Let's flag the 10th and the 11th, just the afternoons. Yeah, I think let's do 1:30. So we'll note we need to get through the questionnaire because we need to start getting those printed.
Can I issue an order like you did last time?
Yeah, no, I'll end up issuing an order. I think the ones I definitely will need and want to explore with you all would be the focus on the RICO demurs. So I don't know if we want to do all that on the same day. Maybe we'll divide them up. Let me take a look at again how many different ones we have. I think every one of them has been adopted by Mr. Rafferty, right?
Yes, sir.
Okay.
And I think the other, I'm sorry, I'm sitting, I'm just trying to talk
That's
to the
fine.
microphone. I think the other lawyers did it too, and some asked if their angle can be argued. I think you said no, so I'm not.
I just don't think we have the time. I really don't. And I think that to the extent they've got different arguments that can be preserved, that they will be. It would only be as addressed to particular defendants who have adopted and are here, and that's where we are.
Read the briefs and the response briefs. I would also ask the court to consider potentially considering an interlocutory if that's appropriate, because this is strange areas of RICO based on what you and I researched and talked about that last time. Just because it links to be clarified, so we're not doing this again.
Sure. The only issue with interlocutory is I don't think there's any guarantee that I think the process for that is it's about 45 days for the Court of Appeals to tell us that they want to take the case, and don't have any intention of, now that we've subpoenaed all these jurors, to kick it down the road. So defendants have requested a speedy trial, and we're going to provide one. Anything else from the state?
No, Judge.
Okay. Anything else we can't follow up through an email or otherwise? Okay. Thank you all for your time.